Hello and welcome back to Inside the Contract. We are still on season 2. This is episode number 6. In this episode, we address one of the most misunderstood aspects of FIDIC 2017. Are DAAB decisions binding, final, or both? And what does that actually mean in practice? This distinction matters because many disputes escalate not because of disagreement with a DAAB decision or DAAB decision, but because one party misunderstands its immediate contractual effect. And again, just to remind everybody, what I explained here is the standard FIDIC 2017 mechanism. Always check your particular conditions, governing law, and arbitral rules, because amendments and jurisdictional approaches can change enforcement outcomes. Again, I hope this is clear. Under subclause 21.4, which is obtaining the DAAB's decision, once a DAAB decision or once the DAAB issues its decision, that decision is binding on both parties upon receipt. This means the decision must be complied with promptly without delay, regardless of whether a party agrees with it or not. However, the decision does not automatically become final. Either party has 28 days from receipt to issue a notice of dissatisfaction known as an NOD. If no NOD issued within that period, the DAAB decision becomes final and binding under the contract. Again, I'm referring here to the standard wording, unamended FIDIC 2017 clauses. This distinction is critical. A binding DAAB decision means you must comply with it now. You should not simply ignore it or wait for arbitration. A final and binding decision means the decision is contractually conclusive, the merits of the dispute are no longer open for relitigation under the contract. Okay, you have to understand this distinction because, between a binding and final decision. So a party may disagree with the DAAB decision and still be contractually required to comply with it, at least until the dispute is resolved through the next contractual step. Okay? If a party is dissatisfied with a DAAB decision, the contract provides a clear and limited mechanism. First, a notice of dissatisfaction must be issued within 28 days. Second, the NOD preserves the party's right to pursue further dispute resolution. However, issuing an NOD does not suspend the binding effect of the decision. The obligation to comply remains unless and until the decision is revised through the contract's dispute resolution process. Okay, so what if the DAAB is wrong? Someone may ask. A common misconception is that a party can refuse to comply simply because it believes the DAAB made an error. That is not how FIDIC 2017 works. Even if a party believes the decision is wrong, the decision remains binding. Compliance is required in the interim. The disagreement is preserved through the NOD. In practice, tribunals may view non-compliance unfavorably, so keep this in mind, which can influence costs, interest, procedural orders, depending on the case and the rules. Again, depending on the case and the rules. Enforcement of binding but not final DAAB decisions has been addressed differently across jurisdictions. Okay? FIDIC's intent is that FIDIC 2017 intends DAAB decisions to have real interim effect. The contract does not treat them as advisory opinions. However, enforcement strategy matters. Different legal systems and arbitral approaches may require framing enforcement as a failure to comply dispute, seeking procedural or interim relief rather than re-arguing the merits, again, dependent on your legal jurisdiction. The key takeaway is that binding means binding, but the route to enforcement must be carefully structured. Again, always subject to the contract wording and the legal jurisdiction and arbitral rules, okay? Okay, in the case which it happens on many projects, what if no DAAB exists? FIDIC 2017 anticipates real-world situations where a dispute arises before a DAAB is in place, or while the DAAB is not being constituted. This is addressed directly in subclause 21.8, which reads no DAAB in place. In such cases, subclause 21.4, obtaining the DAAB's decision, does not apply. Subclause 21.5, amicable settlement, does not apply. Again, in theory. In real practice, this may be different dependent on the parties and how they negotiate with each other. But I'm talking about in theory based on the standard text of FIDIC 2017. Instead, either party may refer dispute directly to arbitration under subclause 21.6 without prejudice to other rights. This clause exists to ensure the dispute resolution process does not become paralyzed due to the absence of a DAAB. Okay, again, I'm mentioning this. This assumes the contract is unamended and the DAAB is absent, okay, which is covered under the 21.8 in this case. Okay, we come to a real challenge. What happens if a party refuses to comply with DAAB decision? Again, if a party refuses to comply with a DAAB decision, the consequences depend on whether an NOD was issued. First, if no NOD was issued, the decision becomes final and binding. Non-compliance is a clear contractual breach. If NOD was issued, the decision remains binding in the interim. The other party may pursue enforcement, including referral of the failure to comply as a dispute, subject to the contractual route and tribunal approach. Again, in both cases, refusal to comply carries real contractual and procedural risk. Okay? So, if we look at it from different perspective, employer or a contractor, in practice, DAAB decisions often expose differences in risk behavior. This is the typical behavior. For example, employers may delay compliance, hoping the issue will be revisited later or for leverage. Contractors may rely on the binding nature to protect cash flows or, out of caution. So FIDIC 2017 is designed to discourage this gamesmanship by reinforcing the comply now, argue later principle contractually, not politically. Okay, so let's look at really the practical takeaways. 4 critical lessons, for professionals. First, the 28-day NOD deadline is strict and usually treated as a hard deadline under the contract. Again, subject to validity of notice, amendments, and very exceptional arguments. Miss it, and the decision becomes final and binding. Second, binding means comply immediately. Disagreement does not excuse non-performance. 3, interim enforcement is real, but strategic. The way enforcement is framed can be decisive. 4. Early DAAB appointment matters. While clause 21.8 allows direct arbitration if no DAAB exists, failing to appoint a DAAB early removes the benefits of dispute avoidance and changes leverage, timing, and cost exposure. Okay? So, just to close, under FIDIC 2017, DAAB decisions are not advisory, not optional, and not safely ignored. Okay? They are binding when issued, final if not challenged in time, and central to the contract's risk allocation philosophy. Understanding and respecting the structure is the difference between controlled dispute management and contractual self-sabotage. Okay? By this, we come to the conclusion of episode number 6. And again, as usual, I thank you for watching. As we move to the next episode, we explore a fundamental truth in FIDIC administration. Why claims often fail